There we go. Okay, we're about to get started, so anybody in the hallway, get in here. And we have one more administrative thing. Is there a Janet Handel in the audience? Janet? Well, if you meet a Janet Handel out on the street, she's looking for her driver's license. It's right here. All right, are we ready to go? Great. So welcome back. And we now have our panel about legal and marketing and social media, friends or enemies. And first we're going to have the panel members introduce themselves. So we'll start on the end with Susan.
Hi, I'm Susan Shook with the Procter Gamble company. I lead a global team of lawyers who handle global digital and privacy law. And we've been practicing in the space about 4 to 5 years, which seems like forever now. But it's amazing the amount of change that happens even within 4 to 5 months, or even 4 to 5 weeks.
I'm Kathleen Hartnett, and I'm the social media lead for part of the consumer engagement group, and I'm at Pfizer Consumer Healthcare, and we've been in this space a little over 2 years.
Hello. Hey, I'm Jerry Stegmeyer. I'm an attorney at Wilson Sonsini GoodRich Rosati. You can follow me on Twitter at 1S and 0S Lawyer, and that's the essence of what I do. I help companies do business online, globally, in particular in social, but as you can tell by my gray beard, I've been at this for a while, and we represent 65% of the venture-backed software companies in the United States and work with many very large brands in figuring out how to work with and get into this space. So we're not no guys. We like to say that we help you go from no to go, which we think is a little different.
And I'm Peter Friedman, the CEO of LiveWorld, which I already told you all who we are. For disclosure purposes, I should point out that Procter Gamble and Pfizer are both clients of LiveWorld, and Jerry works at our law firm. But they're all too modest. Jerry is actually a world-renowned expert in cyber liability law. Kathleen at Pfizer is overseeing many of their consumer brands, such as Chapstick, and what happens to them and doesn't on social media. And Susan is actually overseeing legal matters in digital and social worldwide for, what is it, 300 Procter Gamble brands or something like that? Many of them, right? Yeah. We don't work on all of them yet, but we're working on that. So we're going to go over a bunch of different topics and questions, and now plenty of time for questions from you. But first, we'd like to ask you a question. How many people here work for a brand, either as an agency or in the brand? A whole bunch. And how many of you feel you've ever had an issue with legal? Well, that's funny. More people put up their hand the second time than the first time.
Did you all just text message me 2 minutes ago?
Okay, well, we're going to want to hear all about that from you as well. So let's start. We'll start with Kathleen, because Kathleen is on the brand side. So we have a brand person, an in-house legal person, and an external legal person, and a social media firm that works with all those people. What problems do you find that legal groups, or you've run into with legal, and how do you go about addressing them?
I joined Pfizer actually at the end of 2010, and one of the first things that I realized is that I needed to build a relationship with our legal team across all of our brands. We actually have 9 brands that are very active socially, and to be honest, the lawyers needed to be my best friends if we were going to survive at all. I came on trying to introduce one brand to Facebook, which quickly grew to 7 brands, and now we're also on Twitter, Pinterest, Instagram, as well as other platforms. And the legal team, I literally met within the first week walking in the door with every lawyer that supported every one of our brands, and sat down, introduced myself, as well as I came from the agency side, so I had social media background from the agency side, and sat down and talked to them about all the pros, the rewards of doing things, and actually what are the risks, and had very frank discussions over the period of 6 months on some platform, and actually as long as a year on other platforms of what were the positives to the business and what were they going to be, and from their standpoint, what were all the risks going to be. And literally working through which each of these lawyers, based on brands, because we have brands that range from low risk, which would be ideally chapstick, to more high-risk types of brands, such as an Advil or potentially a Robitussin. They're all OTC brands, but they're all FDA regulated. We have a lot of nutritional brands, such as Emergen-C, also very active in the social space. So it was really forming a bond with my legal team, and I'll actually have to say the legal teams that I work with are different for each group of brands, but they are some of the most fantastic people I ever worked with. And initially, the first conversation, to be honest, it was, no, I don't think we can do that. And very quickly, over the course of a few weeks, and spending time with them and helping them understand my point of view and myself understanding their point of view, we were able to work through what had to be done to mitigate all risk. And really, that's a lot of what we spend a lot of our time doing, is mitigating risk, making sure we've kind of gone through what are the potential problems that we could encounter, what would be the process to solve those if they do occur, and how do we talk to our consumers in a very real fashion, but in the background being very planned.
Okay, let's go to the lawyers, and it's like they're in the witness box, and I'm asking them a question. Yes or no? Is a brand liable for the content a user posts on the brand's Facebook page? And where were you on the night that content was posted?
Do you want to start with Jerry or with me?
Yeah, so, I'll sort of take it. I think, if we think about the beginning point of Peter's question, I think the place to really start in this space is to recognize that, for the most part, the offline rules apply in the online world, with some very interesting exceptions in this space, which largely relate to intellectual property, which there are some variations under the Digital Millennium Copyright Act, which in essence says if someone tells you something is infringing and you've registered a DMCA copyright agent and you have a repeat infringer policy and you take it down, you're probably going to be okay. The second part of that is if the content comes from someone else and you're an interactive computer service provider, so think a message board, your Twitter, your Facebook, and someone says XYZ is really great, you're probably going to be all right, with an important exception there, which is the way we think about it, and I'll let Susan sort of jump over to this piece because I think it's really important for her brands, which is it's hard to adopt something that you couldn't otherwise say yourself and make it your own. And so the FTC has some guidelines, and there's some very specific risks. So for the most part, offline and online are the same, except for IP and then this other content issue. But maybe you want to react.
Yeah, so there's a famous case that you've probably all heard of, Quiznos versus Subway, where Quiznos wanted to do a head-to-head kind of meat competition. Even their URL was meat, no meat versus Subway. So what they wanted to do is get consumers to submit user-generated content videos on why Quiznos was better than Subway's footlongs or whatever it was. And so the call to action of the contest basically said, hey, tell us why Quiznos is superior, in essence, to Subway. And Subway brought a claim saying, you're not immunized by several of the statutes that apply here because you've basically asked the consumer to do what you wouldn't be able to do in terms of making claims yourself. The case ultimately settled, but what I would say we see from that and other cases that have come down the pike since then is, as a general rule within our company, we tell our brands, don't incentivize or do a call to action for consumers to do something that you wouldn't be able to say yourselves.
So if the brand is effectively hiding itself in consumer clothing, almost manipulating a result that they get in trouble if they did themselves, that's like bad. But what if it was Quiznos and they didn't do that and people just started putting up content about how they like Quiznos more than Subway?
I think at that point, and this gets kind of what Kathleen was talking about, was sitting down with your team and talking about all of the different risks. So there are legal risks, there are PR risks that you need to deal with. And as a team, you need to define before you start how you're going to deal with certain type of postings, what your reaction is going to be. And so if you get certain types of posting where you think you should be moderating the content in order to reduce PR risk, even if some heightened risk, legal risk may come up, that may be the right way to go once you get all the stakeholders involved in the decision making.
So one of the things that we think about, to Susan's point, is, what is our role? What do we do? And we have a very straightforward methodology for risk management, right? We identify risks, we put them onto others, if you will. We remediate them, right? We address them on the back end, or ultimately we accept the risks. And that's our toolbox. And that last one, accepting the risk, what we like to say is mistakes are okay if you make them on purpose. And just to give you an example of something we recently encountered, I think is a good example of a risk you might wonder about, which is I was looking at some social media guidelines, and there was a question about if a celebrity who, on an unsolicited basis, says something nice about your product, could you retweet that, and when and how? And it was interesting because the legal discussion that came up, and that's not exactly something I do, but the concern was that if the company retweeted, would the celebrity come back and sue them for trading on their brand, for just repeating what the celebrity had already said? And so there were baked into these guidelines very specific discussion about whether or not there was a pre-existing relationship with the celebrity. And the flip side of that is if you have one of those relationships and someone is compensated, whether that's being disclosed.
Also with some of that, I think that goes with each company and how their own legal team wants to address certain things like that, because we have very specific process for things like that. A lot of it working with lawyers is being somewhat specific on what you can and cannot do. So above and beyond when you're in a regulated space, you have things to worry also about a product complaint, an AE that needs to get reported to an FDA within 24 hours. Things like that, product inquiries. What do you handle physically in the social space and what's taken offline? So a lot of that also needs to be prepared for before you literally get out and start moving forward. One interesting thing when we started putting all of this together and meeting with lawyers is right now we have a database of probably close to 10,000 answers to different questions. We've also worked with our care facility. So anyone who calls our 800 number to ask a question, we have all of those questions also vetted for social. So we really anticipate as much as possible what will be coming in. So in addition to things like retweeting, what if somebody uses our product incorrectly or something happens? What are all those processes that are also in place to make sure there is little to no risk on a daily basis?
Go ahead, Susan.
And I was just going to pick up from your first question for Kathleen about, working with legal and saying no. I think one of the pressures that we sense when we're putting together social communities is making sure that the brand, the marketing, the PR folks understand the amount of time it takes to put together a network like Kathleen was talking about. So you need to map out the difference between this and I think 5 and 10 years ago and more static advertising, offline advertising. A claim came to an advertising attorney, you reviewed it, you made sure it was substantiated, you got all the rights management taken care of before it launched. And it was more of a discrete process. And this we've introduced now the consumer and all the things the consumer may say. And so you have to work as a team to plan out or anticipate what the consumers are going to do on your platform. The different routes that they may, you may think it's a fairly innocuous post. It could go 5 different ways. You need to think about those in advance, have your prepared responses, and have your team for the ones that aren't prepared. Who are we going to call? Are we going to call regulatory? Are we going to call legal? Do we need to call PR?
But Susan, why? That seems like a lot of extra work.
Because this is supposed to be a positive experience for your consumers, right? So we want to make sure that you have, you still have the human behavior involved, but you're directing in a way that meets the value proposition for the brand and what your goals were before you set out. And that's another important part of the whole equation. Set your goals and then look at all the pros and cons from the different stakeholders involved in the process. And that's why you can't come at the 11th hour and say, we want to put up a social community tomorrow. That's why you get the lawyers going, hold on a second, we're going to have a lot of players, not just the legal team, but other stakeholders and experts as well, even information security folks, if you're going to run promotions and collect personal information.
Does that ever happen? Somebody comes in at the 11th hour and, for example, has a very public-facing brand with a big sports star and says, oh, we're putting this Facebook page up with a photo contest tomorrow. Did that ever happen to you at the 11th hour? Something like
It
that?
depends how we define 11th hour. So it may not be, 11 o'clock the night before, but we do get things within, 1 week that involve multiple vendors, multiple platforms, and that takes a lot of work to get out. And so I think, again, if the best advice I think you can get from any legal team is start early, define what your goals are, and then be open to other solutions too, because I think that would be my other concern is sometimes people come in with, I'm locked and loaded on this with this vendor, and it's launching, a week from now. And if you're not open to suggestions on, it maybe isn't that binary, we have other risks that you haven't thought about, it may be a difficult fight with the other stakeholders versus if you park all of the issues aside and say, let's look at what you want to achieve with the proposition, and then have everyone come together with their expertise and their creative solutions to help you meet your goal.
Yeah, I mean, one thing is social's a long-term commitment, and that's another thing. It's not a short-term promotional fix. So a lot of the things we do, we need to look forward and say, what's going to happen 6 months from now, a year from now? You can't have a community that's got 3 million fans and all of a sudden tomorrow saying, I'm turning it off without some backlash. So what is the long-term vision, and what are you really trying to accomplish with that community or that group or that set of Pinterest boards that you're putting out there? I mean, what is the objective of it short term? And be very clear about that.
So one of the things I'd like to contrast a little bit is a startup, sort of pure, 3 people in a napkin at a coffee shop, and a large brand, and where that process is different. And as you're all, if you're familiar with A/B testing, I'm sure you all are, right? So one of the things that we encounter, to Peter's question, is people want to A/B test, they want to pilot something small scale, that frankly have a very, little tiny budget, and they do come often, much, much later. So one of the things that Susan, I think, didn't really suggest to all of you, but I think is a key takeaway, is they have a dynamic, close working team relationship. And the way I'm fond of saying this is, when I think about marketers, I think of them as chocolate lab puppies. And I love chocolate labs. Everybody likes the chocolate lab. They're fun, they're adorable, they're the most loyal pets ever. But when you first get them, until you have them trained, they poop on the rug, right? So we have to train them and get this relationship so that we don't walk into the family room and go, oh, I love you, but I have to hit you on the nose with the newspaper because I'm not a dog whisperer, right? I prefer the dog whisperer method. But so it's really important because the risk tolerance in the early stage company that doesn't face the same kind of liability, that's never heard of what an AE is, or the FDA, or any of those other concepts, is a really different sort of environment. So one of the big things that we have to do is get those perspectives to talk to each other better, and that's training the labs.
Well, when you're training the marketing dog, what would you tell it about marketing puppy? Pretty puppy. What would you tell it about risk and the cost of risk and how to look at that?
Make mistakes on purpose. In essence, the last prong that I talked about, risk management, you can make mistakes, but make your mistakes on purpose. Consciously accept the risk. And if you've never talked to your legal team, then you're not doing that. And I talked with the lawyer on Friday. He said something really thoughtful to me. He said, most stupid ideas get outed without me ever having to say anything as the lawyer. And so he said, something boneheaded will come along, and he'll be sitting there, and they'll kind of look around the room, and then he never ultimately has to say anything, but every now and then he does. And so if you have good people and good teams, I think things seem to really work themselves out, and that means having the right outside advisors, having the right internal personnel, and really getting leverage.
And, okay, so another question, I asked about the liability for user content, and we sort of got an answer, but I guess that's the answer. It sort of depends. What about looking at the content, moderating it? Do you have to look at every piece of content? Do you have to look at it before it goes up or after it goes up, or how would that vary?
Well, I think that actually varies on company. In the pharmaceutical space, regulated, we look at everything. We pre-vet every post. We look at every piece of content. And it's not just myself. It's actually a team of people who see the content. LiveWorld actually moderates it. We look at every piece of content, and not only from a marketing perspective, which we like to learn from all of that content, we also look at from a safety perspective to make sure that we're catching everything that we should be on a regular basis. So we are incredibly thorough with everything that goes on. But I really think that that has to do with where we sit and the space that we live in. You know, I know every post, every lawyer. I work with medical, regulatory, trademark, and they all see everything that we talk about before it ever sees the light of day. Public relations as well as marketing, and all in agreement. And we post on an average day on each of our assets probably 3 to 4 times. So about 50 posts of some type or tweets a day. And each one of them can have hundreds of comments by the end of every day. And all of that is looked at on a regular basis. Just to make sure we're still going in the right direction, and to make sure every right channel sees everything. So if it is something that our care center needs to get involved in, they can. If it is an AE that needs to be sent to the FDA in less than the required 24 hours, that's worked on promptly. If there's some possible product innovation that we might want to capitalize moving forward.
Susan, you have a very wide set of brands that go from the pharma end to batteries.
Yeah.
What's your take on this?
So consistent with what she said, I think it varies by your brand. And that question, so whether you pre-moderate versus post-moderate, how quickly you check can depend on the brand itself, the brand's history, what has gone on in the recent past from a PR standpoint or legal standpoint. It can depend on your jurisdiction. Obviously, if you're more highly regulated and you need to be reporting certain things or handling certain consumer comments, you're going to have probably a different mindset than you will I'll bring 2 brands of ours out. Bounty paper towels probably handles it very differently than our Vicks brand. And I would say, it takes a bigger village to raise a more regulated brand in terms of the planning, knowing what you're going to do in terms of pre and post moderation and how you deal with those throughout your organization, what specialists need to be involved.
So I'd add to that you mentioned jurisdiction. So what market segment you're going after and where you are in the world, it can be quite different. In the case of Procter Gamble, they've had worldwide programs for always. They're just targeted at teen girls. And in France, the laws around regulation of social media and content for teen girls are very, very specific and different and much tighter than anywhere else. Now, you might not have thought that would be France, but it is France. So the rules you would execute in the United States or England or Spain, that's one set of rules, but you have to deal with it differently. And there's cultural aspects. It's not just that that's the law in France. It's the law in France because the culture in France has various things going on for it. Whereas in the Netherlands, you don't have those laws. In fact, if you're too tight, nobody will look at you. Because in the Netherlands, it's a more liberal culture, and they actually object to things being tightly managed, and also market segments. If you're too restrictive on teens, they won't show up. And that's a very tricky one to balance.
So Peter, to react, I think there's a really easy way to think about that in this space, which is technology doesn't care about boundaries, but the law still does. So I had a company once, I asked, well, where's this promotion going to be? And it was, I think, $200 worth of prizes. But the legal bill, they said, well, it's on the internet globally. This was about 4 or 5 years ago. The legal bill to clear the promotion was $300,000. And we did it, 72 hours, but I'll never forget the lawyer at our client saying, we're going to do this, we're going to spend this money, and then I'm going to charge this bill to that VP to explain the lesson that, it costs a lot to do this. So I think, simply put, technology doesn't care about geography.
So there's
What
a
the law
good
does.
tip in there for you. If you go to your legal department and you have a whole budget that factors in risks or what measures you mitigate the risks, the lawyer's going to look at it and say, okay, you're organized and you're managing this, and I can now tell your business superiors that you have thought through what you're doing and the cost of executing it. And then they're going to give you a legal opinion on how much risk they think there is, instead of telling your boss they have no idea what they're doing, shut it down. Right?
But I mean, that goes back to having a really good relationship. A really good relationship, the lawyer would have said, this doesn't make sense, let me tell you why. I know when we first started and how we wound up finding LiveWorld was, understanding to mitigate risk that we needed to moderate. And looking at, so what was this whole going to cost if we needed to build some infrastructure to do these types of things? And to be honest, it was conversations with our legal team that led us to, how do we put checks and balances in place?
And
They were
just to
very
point out,
transparent.
the LiveWorld cost was less than the cost of the
At the
legal
very
risk.
end, it's
That was the
actually-
ROI, let's just be clear.
Well, there's
Lets
that,
me sleep at night, I'll be honest.
there's that line, if you don't measure it, it isn't marketing, right? I mean, part of moderation is sort of a function of how do we create accountability. And I think most people would say, well, there are benefits to accountability, but you still have to figure out how to apply that.
Susan?
And the only other thing I would say is, as you work with your lawyers, like we said, very early in the process, when you start looking at community guidelines, so you set your community expectations, and to Jerry's earlier analogy of the lab puppy, the lawyers are going to have much more boring language, right? Legalistic type language. You can make them fun. You can reflect the personality of your community. But that helps set your expectations so no one is surprised when you say, this kind of comment is not tolerated within this community.
I'll flip the puppy a little bit. I sometimes think our lawyers are like the puppies in some ways in the social space. They don't use it actively. And some of the best presentations I've done are simple presentations to actually show different types of photo upload tools to our lawyers, and literally sit there and go through Instagram and Flickr and then show Snapchat and see 3 people in there go, oh my God, my daughter has that. And I'm like, let me tell you what it is. Sitting down and taking them through Pinterest for the first time and seeing one of the lawyers who was a quilter who said, wow, I can put my quilts up there. So it was almost the fun. They were looking at it and going, great, I've now learned something. So, marketers have learned to be, a little risk adverse and more buttoned up, and the lawyers have actually put their quilts up on Pinterest. So I think it really does go both ways, and sometimes if you'll let the guard down early and share what you're both experts at. In my case, there's a few of us in my group. There's 4 of us, and there's probably 12 lawyers. But it also winds up being a nice relationship building that we can actually try to stretch things, and they will let us attempt to do that on, on an ongoing basis.
Just to be clear, the kids are not putting up quilts on Vine and Snapchat.
But they want to know what their daughter's doing, and they had a nice, interesting conversation when they went home that night, I'm sure.
Okay, so now, we asked how many people are brands, and this afternoon is heavily focused on healthcare, but could be other industries. So just curious, how many people are in the healthcare pharmaceutical industry? Almost everybody. All right, so everybody knows what an AE is, right? So how do you deal with an AE in social media?
Well, actually, I'll start. We moderate 24/7, so we are always watching all of our assets. And if a comment does go up that it is an AE, we have a very formal process for reporting that and tracking it, all the way from coming off of the page, getting to a set email list of people within Pfizer Consumer Healthcare there. It also then goes through to our internal safety group that actually catalogs it. I get that catalog number back so I can track it on the back end, and then it moves off to the FDA. So we have a very formal process for AEs. We do not, I'm in the consumer health, so it's more things like dietary supplements, children's Advil, chapstick, we do not really get a significant number of AEs that are true AEs. We get things, which I always use as a fun example. People say they are addicted to chapstick, and they put a smile face and 2 hearts after it. The minute you say addicted, that means that you have put an AE out there. We have worked internally and with the FDA to kind of recategorize that if there is a smile face and 3 hearts after it, it does not, it technically gets cataloged, but it doesn't need to move any further than that.
That's the emoticon rule?
Yes, the emoticon rule. What can I say? But those are the things that you learn as you're reporting AEs, what truly is an AE. And how to deal with on an ongoing basis. And, you know, how do you influence? And we actually try to write things that keep people from using the word addicted in that framework without really telling them, please don't use that word.
And now you're laughing, but, you know, for the first year and a half, if it had addicted in it, boing, it went right through the whole thing.
Yeah.
Once we had a history and we could show what it was, the legal department said, okay, we have some history here, we know what we're doing. And there's also an element of, you know, if you're the lawyers, you're trying to protect the company, so you're trying to anticipate. If you do have a problem and you end up in a legal suit or the government thing, what are you going to explain? If there's a history that you based your actions on, that's a lot better than the puppies made it up that day. Is that right? Because I'm not a lawyer. Do you think that's right?
Yeah, so I always think for any crisis, so I do a lot of crisis work, and the story is always the same, which is we're good people, we're committed to doing the right thing. Sometimes bad things happen to good people, but let us tell you about all the good things that we did and show you how we're good people. And so what Peter is sort of describing, right, nothing is ever black or white, but the way you work through the shades of gray is through evidence, right? That's our toolbox. So I have what I call the rule of threes, which is to say, what are the 3 things that I would say to the FDA or say to the Federal Trade Commission or to any regulator that shows we're the good guys, here our cap is white, if you will, and how that works. And sometimes there are innocent things, right? So if you think about you know, whether you have a checkbox, right? You know, we'd say, well, we employed moderation and we've been reporting and we have this documented evidence that shows this is not an indicator of, you know, addiction. And you have, maybe you have the dialogue where you get this history and you go back and you say, hey guys, can we change this? But think about it that way. Whenever you think about how it is that you'll respond, and you're going to read about it in the New York Times tomorrow, what are the 3 things that you will say to show, you know, why and how you were the good guys? And most of the time, you know, if you have those things, you can embrace the risk, I think.
We found that if a company has an organized workflow and a systematic approach, and people that are doing it that should be, now maybe that's an outside vendor, maybe it's an inside group, but it's not, you know, Mary, while she had her other job, might show up on Saturday. It's organized and systematic, and data is tracked. Then, at least you can show you were being responsible. If you don't have any of that, the first thing that's going to hit you is you're a big, giant corporation, and you didn't even bother to be organized about this. You are responsible for what happened. And that makes a big difference. And we found with legal departments, if they see that organized process, that takes a great deal of, well, I don't want to say it takes a risk out of it, but it puts it into managed or mitigated risk, which lawyers can deal with more. Okay, did you have something else, Kathleen? Okay, what about opting in? That's a big thing. Do people have to opt into things, or do they not have to opt into things? Or how do you deal with that?
Where are we pretending to be, Peter?
Thinking for opting in.
What do you mean by opting in?
Okay, so what requires, if we're like on a Facebook page or a community website or something like that, where do people have to opt into what you're talking to them about or sending them information about? Or do you need permission to retweet somebody? You mentioned a celebrity before, but what if it's just, you know, Joe?
So I come back to my original question. Where are we pretending to be, right? The law professor hypothetical, because I think the answer is going to vary depending on where the geography is, what the type of communication is, frankly, what you're doing and what the business's appetite, for risk is. But if you're thinking like, from a sort of generalized rule or perspective, no one ever got in trouble because they had express permission to do something, right? No one ever got in trouble for that. But what happens then on the business side, and I've got these calls before, where they say, can we tweak this language because our click-through rate is down 0.0007%? And I would chime in, to Susan's point, that's often one of those times where as the legal team, we're saying, we suggested that you make this your own and make it work, right? In other words, we thought we were a good writer before we went to law school and we got our degree in English literature, but I tell all of my associates, look, I have the attention span of a hummingbird that's addicted to crystal meth, and I get all of my information on a one-by-one screen. So if I have to think for 2 seconds, it's too complicated, and you all are really adept at addressing that, and you should. But when you don't, or we don't have that harmonized team situation, we don't get there. So quick and dirty answer, there are many situations where opt-in is required, but we probably should, move down some other facts, but maybe others have thoughts.
Yeah, I mean, certain things like our Facebook pages have kind of the rules of the page that we do have there. So people posting on that are agreeing to do that. There's also the Facebook rules that are there. If consumers are posting pictures, and if we would like to have the opportunity to reuse those, we'll actually put a tab up so we will get an opt-in. That by putting this picture here on this page, we now have the ability to use that across other places. So I literally, you've signed away your rights to that photo that you've posted in that location. So it really depends brand by brand, as well as with our websites. If we are going to give you information, yes, we probably do want you to opt in if you're sending us something like that, mainly because we're pharma.
And the platforms too, right? Because a lot of times the platform has these permissions baked in.
Yes.
We've all heard these stories of, oh, they're going to show ads using your picture, huh? Mm-hmm. But their terms of service or other agreement may have that baked in.
And that gets also to, for your own planning purposes, you need to think about from your community what it is you may want to use elsewhere, right? So if you want to repurpose content, you need to be working with your lawyers on what kind of express permissions you may be setting up in place from the get-go so that you don't find some incredible piece of content you want to use later and have no good way to go get that in an expeditious manner. So that's one of the goals we talked about early on. If you define for your community what your goals are, that may be one of them of, I want to take some of this content, I want to reuse great content, work with your lawyers on what that means in terms of getting appropriate consents in place, making sure that you can substantiate the content with your advertising attorneys. But basically, if you follow that golden rule, it helps you set up whatever kind of gates and licenses you're going to need to get from the appropriate folks who are submitting content.
Maybe, Peter, I could give a real example. Yeah. So a company several years back was very forward-looking about communications. They were concerned about email deliverability, and in essence, they said, we're not going to message people unless we have their permission, and articulated this as the policy. And then they wanted to do consumer engagement, and they started to listen. And the question came up, hey, this community talks a lot about our product. We're listening. Can we engage them directly? And that would be like, okay, that's a no-brainer. They're out in public. It's, Facebook or it's one of these sites. But over in this other part of the business, they had a policy that said, unless you talk to us, we won't talk to you. And it was really problematic, right? Because if you're a large brand and that's a worldwide matter, then you have to sort of really rethink how social takes into account things. And it wasn't a small problem, because it was one of these things where it's like, okay, technology evolved, and they, how are they going to deal with this? And that actually had nothing to do with what the law actually was. It just was, this is the way that we do business, and now we want to do it differently.
A similar example of that is over the last 5 years or 6 years, a lot more privacy laws, right? Because people are concerned about their privacy, and there's all this e-commerce. So many big corporations have put in place a lot of security and privacy measures. Sometimes it's because of consumer protection. Sometimes it comes out of the security of their own systems. And that well-intentioned from IT and legal folks turns into all user information must be encrypted so nobody can see it. And that becomes a very firm corporate policy. So now you're the social media group, and you're starting to do something, and you get sent these guidelines. Well, if you encrypted everything everybody put up on your community website or Facebook page, nobody would see it. So it kind of defeats the whole purpose. Well, and if you just take that back to those same people and say, well, this is so people could put up content and they could all see it, they'll go, oh, the policy makes no sense. And then they'll write a new one. So some of the obstacles people run into is because you're confronting a policy that was written even in the modern times that's intended to deal with a different problem. So you have to surface that and enlist people to help you, which is hard to do at the 11th hour, rewriting a whole corporate policy.
So, Elon Musk says, process is never a substitute for thinking. And whenever he encounters a new hire that talks about process, he doesn't hire that person. So when I think about these things, and I think about things generally, and we got a lot of questions and asks for procedure, I always think, well, let's start with the people, right? Let's hire the right people first. And then we said, well, what do we do? And I go, well, trustworthy, loyal, helpful, courteous, kind, obedient, cheerful, thrifty, brave, clean, and reverent. If it doesn't fit within those parameters, we don't do it. And then people sort of, know where the goalposts are. And I think that's often far more effective when the technology is moving fast, right? What do? We don't do evil. And it sounds, very sort of high level and hard to embrace, but when you have those kind of gut checks in place, you're going to get to the right result most of the time.
And I would say that's one thing that our legal group does in this ever-changing gray environment is we look at the legal risks, but we also look at the New York Times rule, right? So we may not know exactly where this particular legal issue is going to land. There's, cases heading this way, there's cases heading that way. At the end of the day, we want to serve our consumer well. We want a positive reputation for our brand. So if someone were to read this tomorrow in the newspaper as a consumer and say, what was Procter & Gamble's brand? What was brand X doing here? It doesn't make a difference whether or not you won the legal case at the end of the day if your consumer trust has been eroded. So that's another one of the planning processes that we talk about with our brands is we can talk about whether you think we're too conservative or we're too, whether you think we're even being liberal on this one. But at the end of the day, let's all take a step back and wheel out what could happen on this with regard to consumer trust that we've taken decades to build up.
Values-driven leadership.
All right, so now let's open it up and see what questions our audience has here. Yes? He's got the microphone for you.
Hi.
If you like, you could tell us where you're from.
Okay, my name is Dana, and I'm from Hospital for Special Surgery. And my question is for Kathleen. You were talking about how every piece of content that you post is vetted. So how far ahead are you planning your calendar? Like, how far ahead do you plan your posts?
Because a lot of ours are campaign dependent. We plan, right now, we're finishing up April. Now, that does not mean we are changing 48 hours before. We plan our calendars about 2 months in advance. We change them regularly, especially from a PR perspective, because things come up on a very regular basis. So we have what's called an ad hoc RC, which is our regulatory committee, that we meet with and can take things through as needed. We can take things through, a half hour before we need it. We don't normally do that. But we do have our calendars are 2 months ahead of time on all of our brands. And ideally, there's, fun social posts within that. There's brand related within that. And we change the percentages on those based on the brand and based on engagement on an ongoing basis. But we've worked very hard to get at least 60 days in advance.
Thank you.
Woman up front here.
Hi, my name's Andrea Basora. I'm with the Insurance Information Institute. We work with property casualty insurers. And I assume you're all familiar with the Progressive insurance case that happened in August, in which it was an underinsured motorist case in which a young woman died. Her brother, the case ended up going to court. Progressive was in the right legally. But they handled it very poorly on social media, and one of the things they did wrong was that their legal department clearly issued a statement, and that's how they responded to all the Twitter activity going on around this case. I'm curious as to how you would negotiate a situation like that in which the company's involved in a legal case, they're limited in terms of what they can actually say and what kind of comments they can make, but in the social space, the importance of being human and not violating that consumer trust is so important, and clearly they were unaware of that, and the case was a big mess for them.
So I have actually a very specific perspective on this. One is we're always honest and we tell the truth, period. The second is, before I was a lawyer, I was a grocer for 12 years, and you often would find yourself confronted with someone yelling at you who was very angry, who you could not get to leave, and you needed your job and you couldn't leave. So what does the grocery store do? And the answer is listen, nod, calm them down, reflective listening, like we've all heard in our parenting classes if you had one of those, and then we gave you a coupon for ice cream and quickly tried to get you out of the building or the restaurant. Now, what does that mean? It sounds sort of trite, but social media gives each of us an opportunity to say exactly what is on our mind, right? I personally have tweeted about Delta Airlines, for example, a number of times. Many people probably have. But when you're on the receiving end of that, hashtag, what do you do? And I think, it's back to sort of first principles of listening, and so that your responses should be listening oriented. And so one of the things with the company we're working with right now is the effort is to directly open a channel to take that social conversation in, if you will, because the person is obviously upset, it's a big deal, but you have 140 characters. And frankly, there are folks who are not interested in, really having you listen. They want to vent, and that's okay, that's good. I let my children, yell and kick and scream and don't stop them, it's okay. I'm not sure that's, and I used to do some crisis PR before I was a lawyer, but I think the most important thing is that people want to be heard, they want to feel like you're listening, and they want to believe that you're contrite. And this is actually a legal piece. We know from the medical malpractice literature that if you are contrite and sincere, you cut the probability of the lawsuit by like 50%. Right? Now, I'm saying, that values-driven leadership, you need to be contrite and be sincere, but, listen. So that's a lot of talking. I'm sorry, Peter.
There are a whole bunch of things to do in a social media crisis. It sure sounds like they didn't do it. And it's hard because you can't take a traditional PR or even traditional legal kind of command control, make it go away. It's really embrace, maybe diffuse. But getting to this specific thing, what do you do if here's a bunch of things and there's legal implications and all that? So our recommendation in a situation like that is on the social media venue, just listen to it, embrace it, be nice, don't have a big argument, point people to another page with your facts. Don't even get into it. And then you give the lawyer that other page. Say, put whatever you want there that's not in a social channel. And over here, then you have to do a lot of best practices. But essentially on a tricky legal issue like that, the key thing is don't get into it there. Let people talk. Make sure they know you're listening. Send them to another place for your facts. Because no matter how right you are, the more facts you try to put in it, the best case is you're not going to get anywhere, and the worst case is you're going to galvanize it worse against you.
Yeah, a lot of times we'll direct to an FAQ page that we'll put up on the .com or to our care center or something like that to get it off the public forum. And, we will say, we're listening to you, we can answer your questions if you, push this link and go to this location. And it will be something that's addressing.
And I think it's true for most brands, as we're talking about healthcare, and we heard Paul earlier talk about trust. If you're hit with something and it looks like you're trying to hide from it, or just be defensive, you're going to break that brand trust. And this is something you have to explain to your corporate PR people and legal people who, if they didn't grow up with this, well, not grow up, but they're not really experienced with this, they may not understand that that's what's really happening because you can't control the dialogue. Let's take another question from over here, this gentleman.
Hi, thank you. I'm Mike Spitz from the Pixels and Pills blog. You manage and monitor a lot of content often in real time. Do you rely on any semantic analysis software or algorithms to help that filtering process, or is it all manual and very human?
Well, it's not manually. We work with LiveWorld, and actually everything goes into you call the tool, which is a master database. And from that, I'm actually able to pull all types of different kinds of information as needed, based on keywords, based on responses, comments, things like that.
Right, that's what I figured. So there is a digital augmentation
Well-
and support for a lot of this management and monitoring of social media content.
Well, when
Or moderating.
when you're scraping the web just to find out what's being said, because you could have tens of millions of things, you often use digital things to find it. When you're moderating or engaging, this is just our philosophy, you need a pair of human eyes looking at it. So in our case, we have technology that makes the humans faster and better, but every single piece of Pfizer content is looked at with human eyes.
person.
But we have technology that enables them to scale that. There are some companies who are in the business of creating technology to look at it for you, and they would stand here and go on and on about how great that works. And then I would stand here and say, human beings don't like to be managed by algorithms, and they'll figure it out. And even if they don't, you're not getting the same result. But you can use technology to help the human beings. Does that answer your question?
Yeah, so it's a combination of the two, basically, in tandem. Okay, great.
I get things automated back, but I also get phone calls if needed very quickly. 1 o'clock in the morning.
It's over here.
Hi, Christine Perino, Klein Davis and Mann. Kathleen, this question is for you, but I imagine that your panel associates might have some commentary on this as well. You say that Pfizer's playing in the social space from an over-the-counter perspective. What would it take for your team to be comfortable doing so in the prescription arena?
Right now, there are some that are beginning to enter.
And what
So I
are
can't
your
talk
criteria?
directly to it, but some of the, disease states are getting into that space.
But they're not, are they branded?
Pardon me?
Are they brand specific or unbranded?
Disease state.
Got it.
And I really have to talk to somebody within that group specifically, because I really only manage just the consumer brands specifically.
Okay, thank you.
So if it's the disclaimer, if I say something smart, you can attribute it to me, but it's not our clients, and it's not the views of our firm. So I'm going to say something kind of trite here, but I think it's significant. Remember Kathleen's conversation about sitting down with the lawyers and showing them what Pinterest was and what Snapchat was. In this particular vertical, I want you to imagine a world where the agency that regulates you has a dial-up connection. Right? Because in many of these government agencies, they're not one generation or two generation or three generations behind. They are so far behind in terms of having a working understanding of just what you can do that the risk profile is amplified. It's more challenging.
And we work with a lot of pharma companies across the spectrum, and they tend to want to do over-the-counter or create a disease state community. Some want to do it, well, it's going to be another brand and we'll sponsor it. Sooner or later, the marketing people point out if the brand name's not there somewhere, why are they doing it? And the lawyer says, well, if the brand name's there somewhere, why don't you just call it that? And then it gets stuck on these other issues. Most of the pharma companies that we deal with want to do a lot more than what they're doing, partly because it's good business and partly because customers can really use it. The biggest gating item, it is not the law as it stands. I mean, what you heard today essentially says you can do it. It's the concern that the FDA can sort of change that law on them retroactively. The absence of guidance from the FDA is the biggest holdback, even on the prescription drugs. Now, there's some like Allegra, that's a client of ours. One day it was ours, the next day it wasn't. It's still governed that way by the company.
And I think there's something really important to think about for this audience in just sort of two areas, right? The way that we market pharmaceuticals, branded pharmaceuticals in particular, has been radically changing in terms of spend. So that's one big driver. And then the second one that I would throw out for you is the way that insurance is marketed in this country is also changing radically, and dramatically, right? If you used to market to employers, maybe that isn't going to be, that way. And so those two megatrends, are layered into social, which is making it, we'll be busy for a long time.
I'll predict prescription drugs will come this way with or without the FDA. It's just going to take longer without them because the market demand and the value to consumers is so high. Another question? This fellow here.
Hi, my name's JC, and I don't actually work in pharma. I work in intellectual property. And my question is quite specific with regards to posting on social media. If, let's say, for example, something in the news is quite contentious, it's a hot issue, and your audience is looking for you to comment on it, but your position is contra to public opinion. You don't want to have to bury your head in the sand. You want to comment. What do you do?
Well, if your brand client came to you with that question and said, well, this is a pretty hot topic, and they kind of want to know what we think, but I don't think they're going to like it, what do you think I should do?
What do you want to do?
Yeah, I'm thinking.
I mean, I say that kind of flip, but I think the first thing we start with is,
Why?
what do you want to do and why?
Yeah.
And then we can, go from there. But that's naturally what I think I would do.
Well, the situation that I find myself often in is that my audience is engaging in a conversation online about something that's happening, let's say in the news. They're looking to you to comment, but you know that your opinion or your organization's opinion is very much against the grain of public opinion. So as soon as you make that comment, there's a flurry of activity. They're all retweeting, they're all saying how, look how this organization does not share our opinion. And so ultimately you don't want to have to comment. You would like the issue to sort of die down and disappear off Twitter, but at the same time, your constituents are looking for you to comment and perhaps even represent their opinion.
I'm going to let the marketing team take this one.
Well, I guess I'm trying to figure out specifically what, is it a comment that you would like to push that agenda of your opinion? And is that the risk? So if something is being said, you firmly don't believe it, you think you have a better, explanation, then you're willing to take that risk and go out there and say, here's what we stand for, and stick to it because that's your belief. If it is something that, you don't have that belief and it kind of goes back and forth, you might want to just let it die down a little bit. Understand there's many different opinions of all of this going on and give it a little time and then go back with what your opinion would be. I'm not sure what the specifics are. If somebody's writing something that you really don't agree with, I might do it in a more traditional format of challenging that opinion, and maybe not on my page. I might have an illegal opinion back that we don't agree with that. So I'm not sure the specifics.
Well, I'll help them give you the example. Composite out of a lot of companies. Big news about genetically modified ingredients in food or pharmaceutical
Gives you
or
cancer.
cosmetic brands. It's big news. Hey, I'm your customers. Do you have this stuff in your stuff or you don't? Or you do, but why aren't you saying anything? And then it just starts to build up on you. And if you don't say anything, it's like they start getting, oh, they're hiding something from them. They're hiding something, a bad company. But there's a lot of complex issues in there. What would you do
Yes.
about it?
Well, it depends on the specific issue. If it is something that you have a product in it, and it really is in it, I might be transparent. Is your product kosher? A question that, something that I live with regularly. So yes, we answer that because we should be answering that question on our products. If it's something that the minute you say the word cancer, that throws it into a whole different vein, and I would not address on the wall.
That's why I really come back to the what do you want to do,
Right.
because I think part of the message is having a plan that's proactive.
Yes.
So that whatever you decide to do, and I think this is what Kathleen is saying, whatever you decide to do in that channel is consistent with your overall strategy.
To everything. So you're saying the same thing if it's in the New York Times, if you write something, you send out a press release that goes against what is being written in the New York Times, again, then you have that there too.
The best thing you can do about this for almost every brand is, before this ever even happens, is be proactive in social media and establish a cultural framework around your brand and engagement. So when this comes up, people know who you are and have confidence in what you're
Yes.
doing. A lot of brands haven't done that because you can't build a relationship in
The
the middle of a
Got Corn
crisis.
Twitter handle. It's a great way to message about corn.
Yeah.
Yeah,
I mean-
yeah. Well, the corn ones come up a lot.
But I mean, trust is key in social.
Yeah, so that there's
they'll
trust.
trust your answer that you're giving them.
Right. So then if you're a brand and you can answer, you can say, well, I could talk about this, but you could also say, this is kind of a medical thing, and we can't really talk about it here, but here's our fact page. They'll trust you on that. But if you're just starting with that, you don't have that trust, they won't do it. The most critical thing is the transparency, though. Whatever you do, be transparent about it. If you're going to open your mouth, you better be transparent because you'll get found out otherwise.
If something like that would actually be to happen, we would actually have a group of people very quickly get together and literally figure out what are the different scenarios we could do. And that would include our legal team and our PR team and our marketing team, and literally go through, here are 3 options, and literally, if we do this, what's the next step, what's the next step, what's the next step, and take it out far enough that we know the chances are we're never going to get anywhere near that far. But we've already at least planned very quickly, in a matter of, an hour, what that's going to look like.
Susan?
And I think it actually throws back to the old world of what are your vision and values, right? So your social media world needs to be consistent with your offline, long-term vision and goals for your brand. So, you don't want a cavalier response to suddenly undo 5 years of what your vision and value is for whatever that proposition you're talking about.
Question over this way. I saw hands. Woman in the front.
Hi, my name is Joanna Belby. Question, I'm assuming you have communications plans in place, like both for traditional media as well as social media. Do you actually run tests in a controlled environment to make sure those plans hold up?
You're saying tests that the posts actually go up or the campaigns actually go up? We do test a lot of different things, to be honest. I see what pretty much most of our posts look like before they ever go up.
No, I mean, I've been hearing firms that are putting together like sequestered tests off-site where they'll test their processes around crisis planning.
Seeing
to
a
make
lot
sure
more.
they work.
We're seeing a
Yes.
lot more
Yes.
wargaming, tabletops.
Wargaming, that's a good
Yes.
Wargaming.
Yes.
Your top 25 execs go at their planning thing, and what are we going to do if a tsunamis hits
Yes.
our nuclear power plant?
Gather up the
And we
social,
do.
the experts, the attorneys, risk, HR. They have to make their decision to respond or what the craft of response to get it approved. I mean,
We have a plan B for everything.
Sometimes
To be quite honest, with anything, like if we're launching a new campaign, we had a campaign that actually ran this week. We actually streamed a concert to our Facebook page. So not only was it figuring out what happened if that went down, but also if somebody made a comment that had off language in there, if somebody said they hated the artist that we chose, that it wasn't in our brand values, things like that. We had literally everything figured out if anything could have happened at that point in time.
do you have the people available to jump in?
We normally plan ahead of time, like 2 days, Friday before we did it. We launched our new campaign on Monday. We literally had a room of people who actually vetted every possible problem that any of us could have possibly seen. And it only took an hour. You get very fast at it after a while. After a while, you pretty much have it down. From a technical stage, a public relations standpoint, or a legal standpoint, what could have happened. We were going to be touching 250,000 people live in a stream, as well as with real-time commenting at the same time. And so we knew there was a potential of something could have happened. But really pretty much figured out all the possible scenarios and how would we do it and what would we post if things happened. Where would we post, how would we handle it, and we're pretty good at it right now, very nimble. You repurpose a lot of it every time, once you get it done.
One more question, and then we'll take more later during the cocktail party. Fellow in the back?
Yeah, question. Do you have I can't help but think of culture, and I was wondering, on your teams, the legal and marketing teams, do you have it sounds like it'd be great to have a cultural psychologist who's also has a PhD in linguistics to Say again? I didn't catch that, right? Yeah. And I mean that seriously, though. Do you have one of those, or do you have someone who, or are the lawyers or the marketers studied and well-versed in the cultures? Because the big deal is Twitter is this massive sea of ecosystems, I'm sorry, more like linguistic ecosystems. So it's all a matter of context. I mean, it's all maybe social, but there's like, what kind of social? In the car, going to the drive-through, or social on the sidewalk where I can be overheard and I speak loud enough so other people can hear me, or at a conference. So is there to distinguish between, have a sense as to what aspect of social a tweet means or communication means, and then what the long-term goal is for the marketing plan, et cetera. Someone there to have that unique perspective that's not weighted by legal or marketing.
So knowing your audience is never a bad thing.
Right. I think everything starts with that, is who is our audience, and understanding that very clearly. There have been times since I've been within the group, we've had outside people who've come in and we've worked with, not specifically to social, but across marketing in general, to talk to targeting these certain groups, what we should be looking at. And again, we try to talk in the same voice in social. It's more conversational in nature, but it's the same voice that brand is talking in other channels also. So it really is more than just social when we look at that from a culture of how we want to address people. I mean, I look at our Emergency group, which is very different. That's a company that we've actually purchased within the last year, but it's a very different personality. It's a different group of people that I'm speaking to versus a chapstick audience or a young mom on children's Advil. They're all very different groups. They're all looking for very different things from us in that space. But the audience, we're going to talk to a young mom in an ad, this kind of the same way, but less conversational than how we're going to talk to her on Facebook. So I can't say in-house we don't have one, but we do rely externally support.
It's certainly, this is the best practice way to go, to think of your social presence in a cultural model. And if you look across all brands, the ones that do the best on a sustained basis, you'll see cultural footprints in their execution on a sustained basis, not like some promo today. But really, this is kind of leading edge for the industry. Most marketing in social media, it isn't really social media marketing. It's traditional PR and digital and ads shoved at people through social channels. But now that people have done that a lot and they're not getting all the results they want, they're beginning to shift, say, oh, we're in a different world and we have to think this way. And on that big recommendation, we're going to end this panel. We'll all be here available later during the cocktail party, and Bob's going to come up and talk about the next item on our agenda. Thank you, everybody.
I'm going to get started right now. I'm Bob Libby. Someone left their driver's license, by the way. Are we proofing? I'm Bob Libby, head of digital and social communications here at Pfizer. Who is this? I have a driver's license. Okay, well, we'll have a raffle afterwards. I'm not a marketing dog, but I did like that line. It's my pleasure, maybe because I'm not a marketing dog, to introduce our keynote speaker. Peter Pitts is president of the Center for Medicine in the Public Interest, a former member of the United States Senior Executive Service. He was FDA's Associate Commissioner for External Relations, serving as Senior Communications and Policy Advisor to the Commissioner. Peter supervised FDA's Office of Public Affairs, Office of the Ombudsman, Office of Special Health Issues, Office of Executive Secretariat, and Advisory Committee Oversight and Management. He served on the agency's Obesity Working Group and Counterfeit Drug Task Force, and is a special government employee consultant to the FDA's Risk Communications Advisory Committee. In 2010, he was named by Modern Healthcare magazine as one of the 300 most powerful people in American healthcare. Peter's comments and commentaries on healthcare policy issues regularly appear in the New York Times, the Los Angeles Times, the Washington Post, the Wall Street Journal, Financial Times, Health Affairs, the Boston Globe, BBC World Series, that would be nice, World Service and World Series, for those who are keeping track, Fox News, and the NewsHour with Jim Lehrer, among others. His Twitter handle, by the way, is @PeterPitts, P-I-T-T-S. Peter has served as an adjunct professor at Indiana University School of Public and Environmental Affairs and Butler University. A graduate of McGill University, he's married to Jane Mogul and has 2 sons. Ladies and gentlemen, please join me in welcoming Peter Pitts.
Thank you for the kind introduction. I wrote it. I have a slide, if it can get put up there, please. So I am, in fact, a former government employee here to help. Before I start, let me mention that I blog every day at drugwonks.com, so please favorite me. It helps in my rankings. Bob mentioned my mysterious Twitter handle of @PeterPitts, and I'm on Facebook all the time. Who here is on Facebook? So friend me and I'll friend you back. We can get to know each other that way. 1 second. Okay, well, the slide I'm going to show you is one of these things where I'm not quite sure whether anybody gets it, but I like it, so I use it. I'm curious to see what you think here. So it's social media in a regulated environment, or how I learned to stop worrying about user-generated content and love the FDA. So speaking of puppies, who here has a dog? I have a dog, and the best quote I ever heard about social media was that social media is free, like having a puppy is free. So Peter, I tipped your hat to me. You guys have seen this movie, Dr. Strangelove? It's my second favorite black and white movie. And I'm glad that there are enough people in this audience who probably actually even remember black and white television, who remember when cable meant a telegram, and fax meant the opposite of fiction. There are people here, myself included, that remember that when you watched a Fox network, it's not something you told your parents about. All this to say that having a website does not replace having social media insight. Times change rapidly. The late Zig Ziglar said, if what you're doing isn't working, try something else. If what you're doing is working, try anything else. And while I think there are certainly anecdotal social media success stories, we in regulated industry are losing the war, and it's really time to reconsider what we're doing, or probably more precisely, what we're not doing. The use of social media by regulated industry is faltering because of FDA phobia. We've heard a little bit about that. Fear of being challenged by consumers, corporate timidity, and a basic misunderstanding about what social media really is and what it does. Or as John Mack so delicately put it to me the other day, how can you use social media if your company doesn't trust you? During a past episode of Mad Men, the creative team at Sterling Cooper was hard at work brainstorming on a woman's product campaign, and someone asked, what do women want? And Roger Sterling comes strolling by and says, who cares? Well, when it comes to social media, what does pharma want? And who cares? What pharma wants, or should want, is permission from the FDA to guide itself. And that permission has been granted. The December 27th, 2011 draft guidance responding to unsolicited requests for off-label information about prescription drugs and medical devices offers sound counsel, but not much in the area of direct guidance. Nevertheless, there really are important and valuable lessons to be learned if you're willing and able to read between the numerated lines. This draft guidance doesn't address many of social medias referred to in the document as emerging electronic media. It doesn't really address any of these red flags that we talk about, such as adverse events, the question of property owner versus property user, or a more precise definition of what sponsored means. But the giant regulatory bugaboo, not only of social media, but of regulated speech writ large is off-label communications. That's what it boils down to. So those who are complaining that this draft guidance doesn't offer comprehensive enough guidance doesn't really understand what it has to offer and probably hasn't even read it. Let me give you a couple of lessons I think we can take away from this draft guidance. In plain English, lesson one, the FDA is saying, in so many words, if you wouldn't say it offline, don't say it online. A question of platform-specific guidance, regulatory rules for YouTube or Facebook or Twitter. Rather, the FDA is asking industry to use your best judgment in this new emerging media. And that's good news. The bad news is that many folks in pharma and at the agencies of pharma find this news very frightening. What? Use our judgment? The FDA recognizes companies are already responding to unsolicited requests for off-label information. They're not dumb. They do know what social media is. But what that does mean is that the current procedures pharma companies have in place to address these requests are, when properly followed, FDA compliant. Lesson two, when trying to create processes and procedures for social media communications, draw parallels to existing communications, processes, and procedures. You heard just before, an AE is an AE is an AE. You know, if you were at a cocktail party, so our training goes, and someone says to you, oh, you work at, name a pharmaceutical company. Well, I take one of your products, name of products. I took it, my fingernails turned blue. You're not trained to walk away. You're trained to give them the 800 number. The same rules apply. But that's not a get-out-of-jail-free card by any stretch of the imagination. And just with traditional communications, there's a great deal of regulatory ambiguity and the use, kind of in the FDA's favorite conditional tense, the role of legal and medical review. The burden isn't going to be lifted. The burden is going to be increased. The partnerships between legal, regulatory, marketing, and communications is going to have to be enhanced. Authorities are going to have to be shared. New processes are going to have to be invented. This draft guidance and the larger concept of moving more aggressively into social media doesn't lighten the regulatory burden. It just makes it more feasible. It also says, in my opinion, that responding to unsolicited requests is indeed in the best interest of the public health. Let me repeat that. Responding to off-label communications online is in the best interest of the public health. Let me quote directly from the guidance. FDA recognizes that it can be in the best interest of public health for a firm to respond to unsolicited requests for information about off-label uses of the firm's products that are addressed to a public forum, as other participants in the forum who offer responses may not provide or have access to information about the firm's product. In other words, you, as regulated industry, actually know more about your products than people who are talking about them online. And yet, you're not online. So how is the public health being served? The agency, the FDA, has importantly also made a clear distinction between solicited and unsolicited off-label questions. Again, I quote directly from the guidance. Unsolicited requests are those initiated by persons or entities that are completely independent of the relevant firm. This may include healthcare professionals, healthcare organizations, members of the academic community, and formulary committees, as well as consumers such as patients and caregivers. Requests that are prompted in any way by manufacturer or its representatives are not unsolicited requests. So, lesson three. The message being sent here is don't get too cute. And that's worth remembering because using social media for marketing is okay, but using it to advance the public health takes precedence. One key area that requires greater clarification on the part of the FDA is the definition of an unsolicited off-label request. Does it actually have to be a question? Or could it be a non-interrogative, incorrect statement about the off-label use of a product. Independent third parties who make erroneous statements about off-label use generally are ignorant of the fact that they are making factual misrepresentations. Shouldn't a company be able to respond to factual errors that aren't in the form of a question? Isn't the whole idea here not to play Jeopardy with the public health? The draft guidance makes it clear that misinformation is an important issue. And this also came up at the November 2010 FDA's Part 15 hearing on social media. And this is what the FDA said on that topic in the draft guidance. The internet has also spawned a variety of social media tools that host online content primarily created and published by users other than the intellectual property owner or product manufacturer. In some cases, this online content may not be accurate. Well, it's nice for the FDA to recognize the fact that that actually is the case. FDA clarification is necessary, in my opinion, so that companies can regularly and aggressively correct online misinformation about their products. Isn't it sad that we're sitting on our hands even to correct information about our products that we know is wrong? We kind of get around to it sometimes, occasionally, but it's not something we jump on aggressively and do, and that makes us look bad. Ensuite, lesson 4. It is the responsibility of every company, to correct product misinformation that it discovers not only in social media, but in all media. After all, what would a company do? What would your company do? What would your agency recommend if a factual mistake about a product appeared in the pages of the New York Times? It's the same thing. The FDA draft guidance also offers some very sound and practical advice. For example, when dealing with off-label questions, I quote directly from the guidance. Information distributed in response to an unsolicited request should be provided only to the individual making the request directly to the firm as a private one-on-one communication. People kind of get that. And, back to the guidance, if a firm chooses to respond to public unsolicited requests for off-label information, the firm should respond only when the request pertains specifically to its own named product and is not solely about a competitor's product. So lesson 5, take conversations about off-label use and adverse events, in my opinion, offline and into processes and procedures, and don't use a comment about somebody else's product to talk about your product or to diss that product. The FDA also requires some additional assistance in understanding social media, just a little. Specifically, again, I quote directly, FDA is concerned about the enduring nature of detailed public online responses to off-label questions because specific drug or device information may become outdated, e.g., new risk information may become available. Well, while it's good to be concerned, it's also important to recognize that any piece of information ever written on social media, generally speaking, is going to be available forever for those who know how to find it. Perhaps a better way to address this concern is lesson 6. Companies who respond to posts on independent third-party sites should continue to regularly monitor those sites for future legitimate interventions. Nobody said it was going to be easy. Another questionable comment in the draft guidance concerns the use of brand.com sites, our term, not the FDA sites, as an inappropriate way to address unsolicited public off-label questions. Let me rephrase that in English. The FDA believes that on social media, pointing people to a brand.com site is inappropriate. This is what they said. The public response, again, this is to this off-label request, the public response should include a direct link to the current FDA-required labeling, if any, but should not include links to any other information, e.g. product websites, product promotional materials, firm websites, third-party websites. Because, the PI is so understandable for everybody on social media. Now, why wouldn't a product website, assuming that every word on the site is appropriately compliant, be used? Isn't this where the most comprehensive, up-to-date, and accurate product information resides? In, I might add, the most user-friendly way. If the agency is concerned about the legacy of old online information, they should support options that are regularly and factually updated, such as brand.com sites and apps. The draft guidance also raises the issue of communications with healthcare professionals and formulary committees. Who here deals with reimbursement issues? Oh, you will. For both of these constituencies, seeking a regulatory parallel, again, is useful. If you think about the FDA's guidance on good reprint practices relative to how a rep can interact with the physician face-to-face, sharing off-label information, it gives you a good idea about what would be allowable, within a different world, such as social media. Which brings me to lesson 7. Social media means more than marketing products. We haven't really talked about that a lot. Social media means more than marketing products. It means using this emerging electronic media to advance the public health by communicating factual and timely information. In short, sharing knowledge with those who want it, when they want it, where they want it, how they want it. Lesson 8, and not just when a marketeer wants to. Strategic use of social media can put the pharmaceutical industry back in the public health business in the eyes of physicians and patients. Social media can put the pharmaceutical industry back in the public health business. Lesson 9, it's about judgment. If a company can make a strong case, internally and honestly, that a social media engagement truly advances the public health, it's a strong foundation for ensuring compliance. And I would argue the reverse is also true. Lesson 10, pharma guide thyself. What are the odds, lacking direction, expertise, and experience, that the FDA will deliver some kind of future deus ex machina solution? Expecting the Holy Grail from the FDA will only lead to disappointment and frustration. If industry is expecting to climb the agency's headquarters at White Oak, climb the steps, kiss an FDA relic, and miraculously throw away your crutches, hobbling your ability to participate in social media, there'd better be a plan B. When it comes to social media, the FDA wants companies to do what's in the best interest of physicians and patients. Really. But there's an unfortunate disconnect. The regulatory go-forward proposition of many companies is to avoid any regulatory ambiguity. And the result is a vast regulated healthcare wasteland. Alas, when it comes to social media, in compliance and in the best interest of the public health are still too often viewed as being mutually exclusive. Let me make 5 points that are often overlooked or misconstrued when it comes to discussing social media in the context of regulated speech. 1, there is a difference between online advertising and social media. When the FDA sent out its famous 14 warning letters on sponsored Google links, many pharmaceutical regulatory professionals said, you see, I told you, you can't use social media. And they breathed a sigh of relief. Another sign of an ever-growing regulatory Stockholm syndrome. But they were wrong, because when you read the letters, it quickly became evident that DDMAC, now reincarnated as OPDP, equates sponsored links with paid advertising. And you know what? That makes perfect sense. In the context of those letters, sponsored equals paid. And there are rules for that. Beware, as Benjamin Disraeli said, a precedent embalms a principle. 2, there is a difference between social media platforms and social media content. FDA sent out a warning letter regarding a YouTube video where a paid celebrity spokesperson said that a drug had cured her disease. A decidedly off-label claim, shades of Dorothy Hamill. And some internal reviewers said, see, you can't use YouTube. Not so. If the content is non-compliant, then it is non-compliant regardless of platform. And again, on the positive side, I think the reverse is true. Remember, OPDP Director Tom Abrams has made it clear on a number of occasions that there will not be agency direction on how to use specific platforms, YouTube, Facebook, Twitter, and that includes emerging mobile platforms as well. 3, the fear of adverse event discovery is dangerous and misguided. Industry's regular and public social media AE phobia only reinforces the public's erroneous notion that industry communications are solely about money and marketing, and the public be damned. I was at a drug company, not based in Manhattan, and they said that they actively avoid being in social media for fear of unearthing adverse events. And you kind of get that from a compliance perspective. And I said, let me ask you a question. If you got a call from the New York Times, and they said, is it true that you actively avoid looking for safety information on social media? Is that true? Well, it looks really bad in print, and you look like a schmuck. And it sounds even worse in front of a congressional subcommittee. If industry is not afraid to mix it up in real time with real people, it needs to walk the walk, because social media abhors a vacuum. We have to embrace and rejoice in social media's ability to unearth adverse experiences early and often. We have to live it. We have to love it. Quod erat demonstratum. 4, the fear of user-generated content and off-label conversations is real, but there are a multitude of solutions ranging from moderating comments, which I believe are generally accepted by social media communities as long as they understand and are told the need for such moderation, to corporate responses using a given product's PI and pre-vetted company's webpage. We talked about that before. But these tactical solutions don't solve or even begin to address the issue of property owner versus property user that was discussed a little bit before. And that's an issue the FDA would be wise to address, and sooner rather than later. 5, who's responsible for what? Social media is a big place. Can any single company be held responsible for what's said about itself or its products anywhere online? Clearly not. Consider the current on-the-books guidance, which reads, and I quote, applicants should review any internet site sponsored by them for adverse experience information, but are not responsible for reviewing internet sites that are not sponsored by them. Okay, what does sponsored mean? Consider the oft-heard TV voiceover. This portion of the Masters is sponsored by name of erectile dysfunction product here. Now, nobody in the viewing audience thinks the sponsor chose the speed of the greens or the pairing of the golfers or the height of the rough. But say sponsored on interactive social media and watch the sparks fly at internal regulatory review. It would be very useful for the FDA to also clarify, among other things, what sponsored means. Because at the end of the day, the issue of social media and FDA regulations was summed up nicely by a senior member of the FDA Brain Trust who said to me, and I quote directly, "We need to learn to talk to people the way they talk to each other. We need to learn to talk to people the way they talk to each other, and that's going to create a culture shift at the FDA." Ouch, pretty scary. Social media requires interactive engagement in real time. It requires you to play rather than purchase. And that's a wonderful opportunity because you cannot purchase passion. Mario Andretti said, "If everything seems under control, you're not going fast enough." As social media participation by regulated healthcare companies continues its slow slog forward, here are some issues to ponder. 1, intent. Internal company debates often focus on responsibility for what happens after a corporate comment is posted, and that's important, but what's more important is what drove the company's decision to make the post in the first place. What was the intent? Was it marketing driven, or was it done in the best interest of the patient or the broader public health? Intent counts. Just as the FDA has asked whether or not the speaker and the audience matters when it comes to the issue of scientific exchange, so too is this relevant in helping to determine responsibility for what takes place on a social media site. Now, does this mean that, at least initially, regulated healthcare speech and social media will be more corporate versus product-driven? I think it does. Another issue is control. When it comes, again, to property owner versus property user, what's the difference between sponsorship, generally defined as an exchange of money, and control, a more ambiguous but no less important concept? If you control something, then you can be considered able to prevent something from happening, like a discussion of off-label use. Environment. If you buy a banner ad on Google, that's advertising. But if that ad appears above an organic search that you do not either sponsor or control, are you responsible for the broader environment of that page? Perhaps the best way to approach this is through this thought experiment. If you decided to run a commercial for a statin on the evening news, and during the course of the evening news, there was a feature on the off-label use of statins, would you be responsible for that environment? No. Safety information. Is it a good thing or a bad thing for consumers to spend time interacting with important safety information, ISI? Of course, it's a good thing. So here's a question that's calling for some solid research for you researchers out there. Do consumers spend more time with ISI via the traditional offline brief summary and patient package inserts, or via online click-throughs? The joke at the FDA is that the brief summary is like the Holy Roman Empire. It's neither brief nor a summary. Inquiring minds want to know. If it's the latter, that would strengthen the argument that's important for regulated healthcare companies on both the corporate and the product front to participate in social media for the public good. Commitment. Perhaps the one thing that is the toughest to internalize is that social media is a commitment, not a tactic. Obvious financial and FTE implications here, but more frustrating is the fact that participating in social media means playing with irrational actors, like patients. So much for control. So, rather than rubbing the magic lamp and wishing for FDA guidance, we need to burn the midnight oil and work harder to make healthcare communications via social media a reality, because an educated consumer really is your best customer. Social media is the healthcare Hunger Games of pharma. Predictable, juvenile, and portending grander schemes and themes. How many times have you heard, vis-a-vis social media and healthcare, that pharma is different? And that's true. But consumers are the same. They don't think why pharma is absent from the conversation, and they don't care. They assume it's because the industry has something to hide, or they're afraid of mixing it up in real time with real people, and there's more than a little truth to both of those thoughts. Is social media about collaborating with consumers or cooperating with them? What's the difference? Well, cooperation happens when both sides want to survive. Collaboration happens when they want to thrive. Collaboration means interacting honestly and transparently, and pharma's opportunity within the context of social media is to be the first among equals. Success for pharma in social media will come through collaboration, and that doesn't exclusively mean selling. It's been a painful and swift denuding of influence. Yesterday's experts and avatars don't mean anything anymore. And while various emperors are being exposed as having no clothes, the void is being filled with robust and real-time peer-to-peer communication. But there are many ascendant false prophets. The internet is full of them. Some are well-meaning, some are dangerous idiots, some are charlatans. Where are the people who are regulated to tell the truth? As the saying goes in our nation's capital, if you're not at the table, you're on the menu. If we really want to change our country's healthcare paradigm, we must also change the way people learn, discuss, and address healthcare issues, and that has got to include social media. As NIH Director Francis Collins recently said, quote, "We are living in an awkward interval when our ability to capture information often exceeds our ability to know what to do with it." And his comment was directed at the complete human genome sequence, but it's equally germane to an equally complex human proposition, social media. And may the odds be ever in your favor. Thank you. So what can I tell you? Yes, sir. One couple of questions for cocktails, and the real questions come out.
Yeah, well, anyway, the FDA, Rob, should there be a law passed that everyone in government has to be up to date on communication, full use, to not be up to date on social networks, even the latest, the things that are coming out in the future, would be equivalent to not having a telephone, not having an address?
Well, thank you for that wonderful setup question. When I was at the FDA, I met one of the groups I ran was the Public Affairs Department. I had a meeting, 40 or so people, and I brought a telephone with me. I said, listen, guys, so this telephone comes with buttons at no additional charge. Meaning, don't wait for people to call you. You can actually vibe out, on company time. Whether or not there should be a law, there ought to be a law that everybody in government has a Facebook page or a LinkedIn account or a Twitter account or knows how to do it. That's just silly. It's like saying that everybody in government should not be overweight and have a BMI under 25. And shouldn't smoke. And shouldn't use nasty language or watch The Bachelor. Where does it get you? I think the more important point is, do people in government agencies, FDA specifically for my purposes, do they understand initially the value of social media and then how to constructively allow those it regulates to use it appropriately? And I think the answer is they're beginning to. But here's the truth. If you created a list of the 100 most important things the FDA has to deal with, would use of social media be on the list? No. Nor should it be. But it doesn't mean it's not important. It comes down to a question of ergs and values and resources, just like in industry.
What's the FDA doing to combat the social media sites that don't allow pharmaceutical marketing to be on it? For instance, Facebook, prescription drugs can't even be on there.
Well, that's interesting. So maybe the theory is that the FDA should force people to accept pharmaceutical advertising. I like that. It's an interesting concept. Well, obviously, just for clarity's sake, the FTC controls OTC advertising. The FDA controls RX and device advertising. If sites or magazines or television programs choose not to accept it, that's their privilege, and the FDA can't, nor should it, be able to do anything about it. I think it leaves a tremendous void. I think that people on places like Facebook kind of don't get it all the time, but I don't think it's the FDA's place to educate them. Yeah, well, I guess pharmaceutical companies and products can use Facebook. They can, and we can have an offline conversation about that. I guess the point is, and I agree with you, that Facebook does not understand the value of constructing it in a way that it can be done with greater facility. Well, yes, sir.
I think from many of our collective experience, especially dealing with pharmaceutical clients, clearly there's variation in level of appreciation and understanding of many of the great points that you've made. For those who do understand and do want to participate, ultimately, at least I've found, it's really a matter of return on investment. It's a matter about recreating the infrastructure of marketing and communications within these large organizations to really step up to the opportunities that you present.
Sure.
So if they conceptually understand what you're saying and appreciate it and inherently understand the value of it, it ultimately comes down to a question of operations and logistics. How do we really make this happen for corporations and infrastructure? On the panel earlier, we saw, for example, Pfizer's doing a lot of these initiatives. They're having some success with it. But if it really
Well, I think there's a basic disconnect. So you were at the Part 15 hearing in D.C. This Part 15 hearing, was anybody else there in D.C., the FDA's Part 15 hearing on social media? There were 500 people. There was the Super Bowl of FDA Part 15 hearings. And the room was basically divided between regulatory dorks like me in suits on one side and like the cool social media folks like you guys on the other side. And one guy from an agency stood up and he said, I think that the FDA should have rolling regulations where they regularly, weekly revisit regulation of social media. And everybody on my side was like, really? There was also a degree of hearing but not listening. At the end of the day, Gerald Delpan, who's the head of pharmacovigilance at the FDA, said, how come nobody here has talked about talking to physicians through social media? This is, with the exception of a guy from Sermo. And people didn't hear what he meant. People didn't hear that the FDA communicates to various constituencies, physicians being an important one, not discussed. I think initially, and I think we're very slowly moving off the dime of social media is the new marketing. It's a way to sell product. And that's cool, and it is, but it's so much more. And until we embrace that higher calling, so to speak, of social media, we're just going to get stuck in that same box. I don't really think it's a HIPAA question, because there are ways to be HIPAA compliant in those ways. I think it becomes a question, it's a much broader healthcare question of like the movement towards concierge medicine, where if I pay my GP $5,000 to be on his list of 50 patients, I'll get his email address, I'll get his Facebook account, I'll be talking to him every which way to Sunday. But that's, for me, I can afford it. For the broader population, doctors are concerned about being overwhelmed by email requests, like in Bruce Almighty, when he gets the world's problems on email. And they don't have the time to do it, and then there are malpractice issues as well. So I think the issue of physicians on social media in terms of dealing with patients hasn't even gotten beyond giving a patient an email address, let alone something more interactive amongst a broader audience of patients. Okay. Well, first of all, I take exception to something that was said on the previous panel, that the FDA is kind of like deaf, dumb, and blind when it comes to social media issues. Let me tell you, the FDA, the 1.5 FTAs of the FDA that focus on this issue do a very nice job. Okay. But that's not going to get the job done. The 1.5 FTEs that think about these issues at the FDA are very well informed. But unless and until that number is radically magnified through, God forbid, user fees. Because even when it comes to dealing with television or print or outdoor or brochures, the staff of OPDP, despite its promotion from DDMAC to OPDP, it's understaffed, it's underfunded. The FDA is not as strong, shall we say, in social science as it is in other types of science. I think it's incumbent on industry and agencies that service industry to go to the FDA and share best practices, thoughts and comments, testify in front of committees that are set up to discuss these things. Because right now, for all intents and purposes, the only time a company talks to the FDA about a social media issue is when they've got a product issue on the table. It isn't theoretical, it's practical, and that's a relationship between regulated and regulator, not between colleagues. Thanks very much.